Welcome to Know Your Rights, a programme that explores the legal issues that are particularly important to the Black community and provides you with the information that you need to engage with the law with confidence. I'm one of your hosts, Norman Basigu, and I'm joined by co-host Dr. Jennifer Obaseki, our award-winning legal expert.
In each episode of Know Your Rights, we will discuss two common scenarios relating to an area of law such as criminal law, housing law, or immigration law. They're the kind of scenarios that anyone might encounter in their daily life. The purpose of this programme is to help the Black community understand how the law works. It's not offering specific legal advice, and if you feel that you do require legal advice, you should contact either your local Citizens Advice Bureau or a solicitor. Today, we're going to be looking at housing law.
And here is the scenario. Lekan is a landlord. His tenant, Drusilla, is renting a property from him under a standard assured shorthold tenancy agreement. Under the agreement, Drusilla may not sublet part of the property without his permission. Lekan has not been asked for permission to sublet, but he suspects that she is subletting a room. Lekan is wondering whether he should secretly install CCTV to prove this. If Drusilla is subletting a room, then he wants to evict her from the property. Finally, Lekan is also concerned that Drusilla damaged the fitted kitchen in the property. He wonders if this too might be grounds for eviction. Right, Jenny, there's a lot to get into and a lot to unpick here. And before delving into this, let's begin by explaining some of the key terms used in this scenario. So my first question to you is, what is an assured shorthold tenancy agreement?
An assured shorthold tenancy agreement is the most common form of tenancy that exists really in the UK. It's one that's issued out by usually private landlords to tenants, though some social landlords, which are places like the local authority or housing associations, also might issue these for short-term places. They usually last between 6 months minimum, but they go on to be also usually about a year. So 6 months to a year, and they don't automatically end at the end of the time stated. They actually then roll on and become periodic tenancies, really. So if you have an assured shorthold tenancy, you would be in the property usually for 6 months to a year, and if you're not given a notice to leave, then you will be expected to stay in that property. However, there's been recent discussions, and the discussions in the UK have been that because the housing situation is quite volatile and many families are subject to being made homeless due to the fact that maybe they might grow arrears or just the movement of people because of the cost of accommodation, the assured shorthold tenancy should be increased to a minimum of 3 years. So that's something that's topical and being discussed, but not in place just yet.
Cool. No, thank you for that, Jenny. And with that being said, let's really get into the scenario. So does Lekan have grounds to evict Drusilla? What's your view on that, Jenny?
Well, most assured shorthold tenancies do not allow subletting unless there's the expressed permission from the landlord. And when we say express permission, anything when it relates to property must be done in writing. Usually oral consents are not sufficient. Anything to do with property usually has to be done in writing. And that is a common practice throughout the whole of the legal profession and throughout housing law. So in order for her to really have done this the right way, she should have sought consent, even if it wasn't within the grounds and terms of her tenancy. So within the agreement, if it's not permitted, as Lekan has stated, then she's really breached the terms of her tenancy. So he would have grounds to seek possession, but he would still have to give notice and follow due process.
Sure. Okay. And off that, so my next question is, what is the process that Lekan would have to follow in order to evict Drusilla in this scenario, and how long could that process take? Jennifer?
Now, we've had COVID and the pandemic, so the courts are quite backed up.
Okay.
They've started to hear possession hearings since September 2020, but there's still a backlog. So first of all, he'd have to give notice. And given the fact that he's saying she's breached the terms of the tenancy, there's two ways he can actually try to get this property back. One is by giving a Section 21 notice, which is saying, I just want the property back, and that's that. And the other way is to say through a Section 8 notice saying, you've breached one of the terms of the tenancy and I want my property back. Now, landlords often just go straight in for the Section 21. I want my property back regardless of the situation. The reason they do that is because under the Section 8 notice, they either have a mandatory ground for recovery of their property, so that means that the landlord has to prove that the tenant has breached the terms, and due to the nature of the breach, they should have their property back. Or they'd have to prove that on a discretionary ground, the court should look at the severity of what the tenant has done and give them the property back. Sometimes the landlords don't like to jump too many hurdles. The evidence, finding the proof, putting their case forward, that's a bit much, so they just go straight with a Section 21. The problem is the court system is jammed up. So the government has said, and the courts have also offering levels of mediation in the right situations as well, that landlords and tenants should try to see if they can work things out amicably rather than come to an already choked up court system and wait for a hearing. So Lakon has to think about things. Is it too grave, the breach, that he's not ready to sort of allow for the permission to sublet? Or is he so fed up with Drusilla that he thinks she's damaging the property, she's flouting the terms of the tenancy, and he just wants her out? He might have to spend a lot of money to get her out and also wait quite a while.
Thank you very much for providing that information around mediation, that being an alternative that landlords can take in these kind of situations. But let's assume that Lakon is fed up and he wants to get her out of there as soon as possible and he just wants to really, go for it. What kind of evidence would he have to provide in support of his case, do you think, if he really wants to push forward this and get Drusilla out of there?
Now, landlords have a right to inspect their properties.
Okay.
They have to give reasonable notice that they're coming in, but they have a right to inspect. So he might give notice, go and inspect the property, check the bedding, the living arrangements, see how many cups are in the cupboard. Also see things like correspondence coming to the house. Is it the named tenant on the agreement, or is it somebody else's correspondence? And again, thinking about what is in the property and the level of damage, looking at the tread. Sometimes when you've got so many people living in a house and in a bathroom, the wear and tear on the property becomes so much more because the property is not designed to accommodate that many people. So he has to gather his evidence in that manner and then make sure it's robust, because the last thing he wants to do is give notice, wait the time, pay all that money, put his case together, and the evidence be too weak. So he has to be, and he can also get maybe an admission from Drusilla.
Okay, right. I want to unpick this thing you mentioned, the right to inspect, and I think this idea of secretly installing the CCTVs, I think, are quite interesting. Now, what do you think of this idea of Lakon's of installing CCTV to obtain evidence? Are you allowed to do that? Is that valid? Like, what's your view on that whole approach of installing CCTV?
You cannot record anybody covertly. And covertly means secretly, basically. Okay. Number one, you can only put cameras in communal areas.
Okay.
He owns the property, it's his. But a tenant has a right to a level of privacy for the place that they have rented, so their personal bedrooms. They can't have cameras there. In the bathrooms, there's a level of privacy that's expected on the area and the proportion of the place that you rent. And it doesn't say she's rented a room, it says she's rented a house. So if she's rented the whole property, he would actually need to have her consent. He could maybe put a camera in the garden area or outside the front door and back door, but not necessarily trailing and pointing into the private areas. So he runs the risk of being sued if he ever does that. And that could be considered two things. It could be considered harassment under the civil law and also harassment under criminal law. And it could also be considered stalking. So he should not do that. No landlord should be, one, recording covertly, and two, recording outside what would be seen as reasonable, which is outside of common parts.
Right, okay, cool. And on to my final question, Jennifer. I'm sure the viewers out there will be wondering, just what sort of provisions are there in tenancy law to help landlords and tenants avoid disputes about damage to properties? Anything that springs to mind in your view about things that can help people in those situations?
Everybody is, understanding of what is reasonable wear and tear. But during this COVID period, the other thing that we have to remember is tradesmen can't ordinarily come into property to do repairs because they have to have the COVID checks. You have to make sure that nobody in the home has been exposed. You also have to make sure that there's nobody in the home that has vulnerable conditions. So even if Drusilla did cause some damage, maybe she's had difficulty with somebody coming in to fix it. But when it comes down to the level of damage, if it's beyond what would be expected from reasonable wear and tear, that's from ordinary usage of the kitchen, if there's like burns, chips, then it shows that she might have been unreasonable and reckless. When renting a property, there's usually a list, and if it's a furnished property, it has a list of what comes with the dwelling, whether there's beds, whether there's marble surfaces or just granite surfaces, etc. And when it comes down to levels of damage, the deposit that the tenants pay is usually there to cover such damage, so that when the tenant is about to leave, there's an inspection and there's an agreement as to whether the property is in a suitable, reasonable condition, or whether there's has to be a deduction due to damage caused by the tenant. So my recommendation would be that there should be a joint inspection of the area that is alleged to be damaged. Okay. Pictures should be taken, and then there should be a discussion as to whether it's reasonable or unreasonable, and whether the cost should be paid out immediately by the tenant for causing that damage, or whether it has to come out as she's leaving because he managed to get the eviction, as it were. But if not, she might have to pay up and have it fixed right there and then.
Right, that's fantastic, Jennifer. Thank you very much for that insightful view on how to navigate this situation and also questions surrounding this topic. And with that being said, ladies and gentlemen, that's it for this episode. You've been watching Know Your Rights. I'm Norman Basigu.
And I'm Jennifer Obaseki. Until next time, goodbye.